Wills. History of wills in Nigeria, pre-colonial and colonial. Before the colonial era, disposition of property took place under the customary law inheritance laws. This was effected mainly through oral disposition. When a man fails to dispose of his properties orally up to his death, the properties would devolve according to the customary law. In a Yoruba land, a dying person can dispose of his properties under the customary law by oral disposition in the presence of 4 witnesses. Under Islamic law, a person subject to Islamic law can only dispose of 1/3 of his property through a will. The remaining 2/3 must be disposed according to Islamic rules as provided for by the Quran. Applicable laws. During the colonial era, will was created. A statutory will is a will created in accordance with a particular statute enforced regulating the construction of the will. Applicable laws are 1. Statute in force, 2. Received English laws in Nigeria, 3. Wills Act 1837, and 4. Wills Amendment Act 1852. The Wills Act of 1837 stipulates formalities for the making of a will that is to be admitted to probate. The formalities are: 1. The will must be in writing. 2. The will must be signed. 3. The will must be signed by the testator in the presence of 2 witnesses present at the same time. Section 9 of the Wills Act 1837. In Akpatire and Akanke 1944, 17 NLR 149, the testator was a practicing Muslim. He made a will and only 1 witness was present at the time of the signing of the will. The court held that though the testator was a practicing Muslim, there was evidence on the face of the will that he intended making a will under the Wills Act. However, the will was held not to have met the requirements of the law and in the circumstance was held to be invalid. What is a will? A will is a document by which a person makes a disposition of his properties, real or personal, to take effect after the death of the person. A will may be described as a testamentary document voluntarily made by a testator with a sound disposing mind in accordance with the will's law, by which he gives directions to persons called executors with regards to the disposition of his real and personal properties after his death. The will is the sum of the wishes of the person making it being reflected in the document called his will. A will is a creation of statute and must comply strictly with the relevant statute in order to be valid. If a will does not dispose of property, then it cannot be accepted as a will. Terms in wills. The person making the will is called the testator. If the person is a female, she is called the testatrix. Where a person makes a will, the person is said to have died intestate. The person is entitled to the properties or benefit under the will is called the beneficiary and sometimes the successor. The total of the personal and real properties of a deceased is referred to as the estate of the deceased. The personal representatives appointed under the will to administer the estate of the deceased are called executors. When the deceased dies intestate, administrators are appointed to administer the estate. Types of wills. Formal will. This is a will made according to prescribed form as required by the relevant wills laws. It is derived from the received English laws and it is required to be signed by the testator and attested to by at least 2 witnesses. Statutory will. These are wills made in accordance with the requirement of certain statutes. Examples are wills made according to the Armed Forces Act Cap 420 LFN 2004 for members of the armed forces. Non-cooperative will. A non-cooperative will is the oral directive of a deceased person to his heirs which are to be carried out after his death. It is usually made in anticipation of imminent death. It is sometimes referred to as deathbed wishes. Mutual or reciprocal will. It is made by 2 or more persons. They are reciprocal because they make provisions for each of the makers of the will. It is an agreement between them to dispose of their properties in a particular way. It is very common amongst husbands and wives where each leaves their properties to the other on the condition that the second to die will leave all their estate to an agreed third party, e.g. their child. Privileged will. This is a will by certain categories of persons in service. Examples are soldiers in military service, mariners or seamen at sea, a crew of commercial airliners, etc. These persons can make will without the required formalities. To this effect, the will may not be written, signed, or attested to. The testator must, however, have the testamentary capacity and intention to make the will. Holograph will. This is a will written and executed in the hands of the testator himself, which is usually not attested to. Prenuptial will. This is a will made preparatory to a marriage. Conditional will. This is a will executed based on certain preconditions which must be fulfilled before the will can take effect. Related transactions. The following transactions are concerned with the disposition of properties but are not wills. Nominations. This is a directive made by a person, the nominator, to an organization or institution or any other person that upon his death his funds in the organization should be paid to a particular individual, the nominee. Nominations can be made only in respect of funds of the nominator and not in respect of other properties. Settlement inter vivos. This occurs where a settlor transfers his property in his lifetime to another living person to hold for him and to take effect in his lifetime. It is different from a will because a will takes effect after the death of the maker. Donatis mortis causa. This is a disposition of property made by a person in contemplation of death, but to take effect only when the donor dies. When the donor recovers from the anticipated death, the gift does not take effect. Applicable laws. A. Wills Act 1837. B. Wills Amendment Act 1852. C. Wills Law of the various states of the Federation. D. The High Court Civil Procedural Rules of the various states. E. Case laws. Advantages of making a will. 1. To avoid the problems of intestacy, wills displaces devolution of properties by customary law. 2. To have the choice of appointing trusted people to administer his estate. 3. The testator has the opportunity to make a positive display or demonstration of his wishes and desires. 4. It confers on the executor authority to start acting immediately and thus saves time and money. Where the deceased dies intestate, the administrators of the property have to apply for letters of administration before they can begin to act. 5. A grant of a letter of administration involves additional expenses of bonds and sureties. 6. The death of the surviving administrator necessitates that a fresh grant of letter of administration be sought and obtained. 7. The making of a will may give the testator peace of mind because he has wound up his affairs. Disadvantages of making a will. 1. It does not enhance community and affinity in the families of the deceased. 2. Additional costs and expenses are incurred in the drafting of a will. 3. Any mistake on the formal requirement of a will may easily vitiate the will. Characteristics of a formal will. 1. A will is testamentary. This means that the will speaks only after the death of the testator. It also takes effect only after the death of the testator. 2. A will is ambulatory. Ambulatory is derived from the English word ambulare and it means moving from place to place. A will remains unfixed and can only be changed, altered, or revoked during the lifetime of the testator. 3. A will must be voluntary. It must be the offspring of the testator's volition. It must be independently and freely made without pressure and undue influence. 4. A will is dispository. It contains disposition of property as well as other non-dispository matters, e.g., burial arrangements and appointment of executors. 5. It is made, signed and attested to in accordance with the provisions of the law. 6. It identifies the property and names the beneficiaries of the gifts in the will. 7. The intention of the testator to dispose of his properties must be clearly expressed. 8. It must be made by a testator with a sound disposing mind. Very important, the propounder is the person who puts forth the will for validity. It may be the executor or one of the beneficiaries. The challenger is the person contesting the validity of the will. Capacity to make a will. The testator must possess the testamentary capacity to make a will. The testamentary capacity include 1. Age. Every adult, no matter his religion or status in life, can make a will under the statute. Such adult must have attained the minimum age of maturity ranging from 18 to 21 years. Section 7 of the Wills Act provides for 21 years. Section 3 of the Wills Law of Lagos State provides for 18 years. In a situation where an underaged makes a will, the fact that he later or subsequently attained the age of adulthood does not confer validity on the will he had earlier made. Exceptions: 1. Soldiers in actual military service. 2. Mariners at sea. 3. Crew of commercial airlines in the air. Section 11 of the Wills Act and Section 6 of the Wills Law of Lagos State. Mental capacity. Soundness of the mind is an essential element of testamentary capacity. A defect arising from mental capacity may render the will void. In the case of Okebola and Boyle, 1998, 2 Nigerian Weekly Report, part 539 at 533, the court observed that no person is capable of making a will who is not of sound mind, memory, and understanding. The testator must possess a sound mental capacity in 2 stages: 1. At the time of giving the instructions, and 2. At the time of the execution of the will. The test for the soundness of mind was laid to rest in the case of Banks and Goodfellow, 1870, LRS QB 544. In that case, 2 delusions disturbed the mind of the testator. The first one being that he was pursued by spirits, and the second one that a man who was long dead always came personally to molest him. Neither of those delusions could have had an influence on him in the course of him disposing of his property. The jury also found that despite these delusions, the testator was in possession of his senses when the will was executed. Cockburn CJ laid the test thus: the testator must have a sound disposing mind and memory. He must understand the nature of the acts of making a will and its attendant effect. He must also understand the extent of the property that he is disposing. He must as well appreciate and recollect the persons who are the object of his bounty. He must understand the manner in which the property is to be shared or distributed among the beneficiaries. Very important, soundness of mind should not be confused with the state of the body and health. Johnson and Maja, 13, Waka 290, Okelola and Boyle, 1998, 2 Nigerian Weekly Report, at 539 at 533. Quick glance note is powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Connie Close of Inimai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 091569137 and send your emails to ronumsandluxury@gmail.com, Instagram ronumsandluxury, Facebook ronumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.